I guess it has to be looked at from a number of different angles. One, you looked at those companies that may be in this position already. We've already had Starbucks, we've already had a number of American companies who have reached agreements with local tax authorities, or they are challenging the EEC rulings that have been made to date. It seems largely that there is no doubt that the EU countries involved were aware of state aid before they entered into a lot of these agreements. They were aware of the rules that concern state aid, and I think now those countries will be looking very closely at this ruling to see whether or not the Commission has actually exceeded its power and exceeded its jurisdiction. And if it has, well then there will be it will have to go all the way to court to actually put that to stop that encroachment of sovereignty. So that's looking at existing companies who have that, and governments that will have to look at the existing regimes that they have. I think it will be each set of governments and companies will also be reviewing what agreements that are still in place to see whether or not they could be susceptible to an attack. And that order will have two benefits. One, from the company's perspective, it allows it to get ahead of the game, if you like, and not waiting for the knock to come on the door, and to get its evidence in order. Some of these agreements were reached, but the time limit on the EU investigating this is 10 years. So companies are going to have to go back to the agreements that were entered into up to 10 years ago and see whether or not what evidence they have. Because 10 years ago was a long time in corporate governance speak. A lot of personnel could have changed, their tax managers could have retired, could have moved on, etc. And that could be one of the most difficult things that they face, is actually getting the right people, getting the right recollections, getting the right evidence together in the case of an investigation. Some of these companies will already have started doing this, and we have seen this, where the auditors have raised this as a question in order for the auditors to determine whether or not a reserve will have to be put in the books of the relevant companies, whether they are listed companies or unlisted companies, and that in itself is a major project. Again, all the information has to be got, all the evidence has to be got, it has to be analysed from the legal/tax/EU perspective to find out whether or not there is a case for which a company could have to answer if it did have to go to, if it were being investigated by the EU. The flip side of that is, of course, if a company, auditors were to find that there were to be a reserve made, well then that would probably be appearing in the accounts of that company, which may not be what that company wants, and maybe a red flag to the EU Commission to what companies to go after next. I think also the governments, if I were advising them, I would be saying, it's now time to ensure that those rulings that you have issued are kept in some form of central database, or there's some means of ensuring that there's consistency in those rulings, that there are no favourable rulings being gathered given to any person or any one set of persons, and yet doing that in a way which does not disrupt the privacy of the taxpayer. The tax authorities should be able to do that, probably better than the individual companies, because companies will not have that information about what other companies have necessarily agreed. If the governments were to take that approach, I believe, then that gives a first line of defence against the EU Commission, because there has to be an advantage to the taxpayer. And if the governments can show, well, here's our consistent agreements with all of these various companies, or X number of companies, maybe on a no-names basis, well then that's quite a substantial hurdle to put in the way of the Commission. I think what's also interesting about this decision is the politics that may be played with it. The Commission has been very careful in how she has not just landed it at the door of the Irish government. She has also implied and suggested, how you want to phrase that other European governments look at how profits were allocated and thus taxed in other countries within Europe for Apple, and also suggesting to the US that they may want to re-examine how the cost-sharing arrangements between the Irish branch and the US operations took place. the US government has not officially taken the bite on that yet, as it's more or less holding firm on the rule of law. So it will be interesting whether the commissioners actually seem to be buying off other governments to get them to buy into what she's doing.